$1 a month can hide $100,000 of injury protection. Professor Iwata studies the rules that turn a traumatic event into an insurance payment. The version going around says full-time SGLI makes every service injury unlock a six-figure check. Watch the service member context, because one word in that claim is doing illegal amounts of work. Every.
Good. Attack the premise first. What is this benefit actually called?
Service Members Group Life Insurance Traumatic Injury Protection, usually shortened to TSGLI. It's an insurance rider, not VA disability compensation, not a medical reimbursement plan, and not proof that a later VA rating will change.
For a member enrolled in full-time SGLI, protection is automatic. The SGLI premium includes a flat $1 monthly charge for TSGLI. That small premium buys access to a listed benefit, but
not an automatic check. Verdict on the viral version, half true. The $1 part is real. The automatic protection is real. But a traumatic injury alone doesn't unlock an automatic $100,000 check.
Off-duty still covered?
With full-time SGLI, yes. Off-duty isn't the disqualifier, but I would still check the policy in force on injury day. Guard and reserve status can change that answer. Fenrir, which gate survives your test?
That's why this episode starts with insured status. From there, it moves to the published loss list, the clock, and the application. If we reverse that order, a polished packet can still be built on a claim the contract never covered.
The benefit exists to support recovery, not to price pain in the abstract. This family moment is the human reason behind a short-term payment. Care, travel, housing, and time can all collide after a severe injury.
Then show us the government's own explanation, not our paraphrase.
Watch this short public domain Air Force excerpt. The people at the desk give way to the eligibility card. Listed loss, published rules, causal link.
Protected, causally linked, listed loss. 3 gates before the money.
That's the hinge. 3 yeses: insured, directly caused, scheduled loss. Then, and only then, the table sets the amount, up to $100,000 per event. Hospital charges don't set it.
And it can coexist with other systems. A TSGLI payment doesn't replace the separate work of proving service connection, a disability rating, or treatment eligibility. Different questions, different records, different decisions.
Tiffany, let me test the strongest version. A member has full-time SGLI, gets hurt off-duty, and later meets a listed loss. We are not disqualifying the claim merely because the accident happened away from the installation.
Correct. The off-duty myth is busted for full-time protection, but the rest of the gates remain. Insured status answers who was protected. The published list answers what was lost. The dates answer when it happened.
And a viewer who is uncertain about guard, reserve, funeral honors, or one-day muster status should use the current VA eligibility page and branch contact information. Similar service histories can produce different coverage facts, so verify rather than infer.
Keep that separation. Coming up, the single loss standard question that separates a serious injury from a covered loss. Quick, honest ask while we are here. If this has been worth your time so far, hit like, then subscribe, and ring the bell. I know everyone asks, but this one is free, and it is how a small channel like this actually grows.
If a traumatic event caused an injury serious enough for surgery, why shouldn't that be enough?
Because the policy doesn't pay for the adjective serious. It pays for a listed loss directly caused by the traumatic event.
A clinician can measure pain, weakness, and range of motion with great care. That clinical work matters, but TSGLI asks a second question. Does the documented outcome meet one of the published loss standards?
So injury, treatment, and scheduled loss are 3 boxes.
Exactly. A traumatic event causes an injury. The injury produces an outcome. The contract decides whether that outcome is a covered loss and assigns the payment tier.
These examples show why guessing from severity is dangerous. They aren't the full list, and the wording around each category matters.
Same body system, 4 different numbers. Fine. The contract wins.
Let me say that cleanly. Total permanent hearing loss in one ear is $25,000. Both ears is $100,000. Recovery care uses different duration standards. The group chat number still isn't published.
The official list is the receipt, not the
Group chat. Rude but accurate.
treatment doesn't equal automatic eligibility. Other categories use time-based thresholds. Traumatic brain injury can be evaluated through coma or inability to perform activities of daily living. Other traumatic injuries can use hospitalization or inability to perform specified daily activities. Those standards aren't a free-form account of a difficult recovery.
And VA expanded certain loss standards in April 2023, including limb reconstruction, more inpatient facility types and therapeutic passes from inpatient care to home. Current page, current schedule. Do not build from a screenshot that predates that expansion.
I thought a long recovery at home should mean the benefit pays. Why doesn't duration prove a qualifying scheduled loss?
Here's the ruling. Duration controls only if the schedule makes it part of that loss standard and the record proves the required kind of loss. Physical therapy or weeks away from work may be real and difficult. Neither fact substitutes for the exact category. The boundary is exact. A long recovery establishes hardship, not a scheduled loss. The current schedule must recognize the category, and the record must prove its required duration or condition.
So if I swap 6 weeks of physical therapy for 30 inpatient days, the same rule applies. The changed fact qualifies only if the schedule names it and the records prove it. That is the whole verdict.
Then the maximum is a ceiling, not a default. A claimant still has to earn each scheduled row and follow the schedule's combination notes.
Exactly. If two categories appear to overlap, stop doing kitchen table totals and read the notes under the current schedule. Some losses can combine, some can't, and the one incident cap remains.
One more safeguard. A payment amount isn't a clinical prognosis. $25,000 doesn't mean a loss is minor, and $100,000 doesn't mean the recovery is complete. The insurance formula prices defined outcomes. It doesn't measure a person's pain, family burden, future treatment, or worth. Keeping that boundary prevents both overpromising and accidental disrespect.
Coming up next, Erica tests what happens when the loss develops later.
An injury can qualify later, forever cannot. The clock has 3 separate gates.
Professor Iwata is back with us to separate the injury date from the scheduled loss date because collapsing them is the mistake.
I start with 2 different jobs for dates. The incident and when the scheduled loss became clinically established. Contemporaneous notes make the bridge easier to audit. Missing notes mean I ask more questions.
First gate, insured status on injury day.
Correct. Coverage must exist when the injury happens before midnight on separation day. That event starts the loss window. A later diagnosis can't drag the incident backward across the policy line.
Second gate, survival. The member must survive at least 7 full days after the traumatic injury. VA states that is 168 full hours, which removes ambiguity about
Partial calendar days. Brutal, but I don't want us to soften it into a calendar tip.
Fenrir, I agree, this is an insurance eligibility condition, not a judgment about the seriousness of a loss or the needs of a family. We can describe it clearly without pretending it's gentle.
Third gate, the scheduled loss must occur within 2 years or 730 days of the traumatic incident. The loss doesn't always have to be complete on the injury day, but the clinical record must connect it directly to that incident and place it inside the window.
injury day, 168 hours, 730 days, 3 markers, not one vague deadline.
Suppose a service member has surgery 6 months later and the qualifying loss becomes clear then.
It can fit, but I won't call it covered from that sentence alone. Verify the injury day policy, the scheduled loss, direct causation, and the 730-day window. The calendar permits development. It doesn't repair a missing causal link.
That last sentence is the one people miss. Time may reveal a loss. Time doesn't create the causal link.
A real consultation should put dates, functional findings, and the claimed schedule category in the same conversation? Generic notes saying patient improving are useful clinically but may not answer the insurance standard.
Tiffany, add one distinction for separated members. Separation does not erase a covered traumatic event that already occurred. The question becomes whether the later scheduled loss is a direct result and falls within 730 days, not whether the person is still wearing the uniform when the loss matures.
That's the useful version. Injury before the policy line closes. Qualifying loss before the 2-year window closes. 2 clocks. 2 different facts.
The clinical record needs the bridge. A date at each end with nothing between them isn't a chain, so the claim is a 4-link chain. Event and injury come first. Loss and date complete it.
Which means each link should be legible to someone who wasn't in the room.
Professor Iwata, thank you for making the clock less mysterious.
Glad to help. Write the dates first.
Dates first, then the evidence chain. Let us build that chain now.
Let's build a fictional file the way a reviewer has to read it. Start by naming the exact category.
Specialist Maya Ortiz is a hypothetical Army reservist. The name and facts are invented to teach the order, not to claim a real approval.
Maya has a thick folder after a covered traumatic event. Thickness is not organization, so the first pass is brutal. Keep the event proof and dates, then keep the medical chain and exact scheduled loss.
But what earns the first page?
Write the traumatic event date and proof of insured status. Then add the claimed loss category and the date it was established. A short index points to the supporting records. VA doesn't require that index. It's a clarity tool for the claimant.
Would you send every record, or only the chain that proves the scheduled loss?
The catch is fit, not page count. 100 treatment pages can still leave the schedule question unanswered.
Start with the incident record, accident report, line of duty material when relevant, emergency record, or other contemporaneous evidence. Then the clinical chain.
But Part B?
The application has a medical professional section. The official Air Force training excerpt in our final scene shows the division plainly. The service member certifies Part A and the physician certifies Part B. The claimant should not coach a diagnosis, but can make sure the clinician has the current loss standard and complete records.
That isn't gaming the claim. It's preventing a clinical answer to a question the form never asked.
Before we crown that packet, give me one failure mode, not another perfect example.
Maya claims an activities of daily living loss, but submits notes that only say shoulder pain and physical therapy. Those notes may be clinically accurate, yet they don't document which covered activities required assistance. They also omit frequency, duration, and why the traumatic injury caused that limitation. The insurance standard remains unproven.
Now highlight the schedule language, then compare it against the records. Green for answered, coral for missing. A pretty packet with a coral hole is still a packet with a hole. Erica, what belongs outside the main chain?
Duplicates, unrelated treatment, and personal explanations that don't establish a schedule element can be separated from the core evidence. Don't destroy anything, organize it. The goal is to make the decisive record visible without hiding it inside repetition.
A thick packet can still mean duplicates and a missing chain. A readable packet is indexed proof where every link can be traced. That's a better standard than thin versus thick. Fit beats page count. No vibes, no adjectives. Match the standard.
Yes, and preserve copies of exactly what was submitted. If the branch later asks a question or issues a denial, the claimant needs the same record set to understand what the decision actually evaluated.
That brings us to the form, the branch address, and the denial letter that controls the next move. The chain is built. Now file the claim form with the listed service branch.
This next part is the one people rewind. Take it slow.
Part A belongs to the member or authorized agent. The official claim form is SGLV 8600, Application for TSGLI Benefits. This footage is generic paperwork, not the government form. Use it only to picture the process while you download the current form from VA.
Yeah, No mystery portal and no choose-your-own-adventure envelope. The current VA page links the form and says the front page lists where each service branch receives the claim.
Part A?
Part A is certified by the service member or an authorized agent. It identifies the member and traumatic event. It also records the claimed loss, payment instructions, and required authorizations. Read every certification before signing. A helper can organize records, but the signature still carries legal meaning.
Part B?
Right. Part B belongs to the medical professional. The clinician certifies the loss and the clinical basis for it. The claimant's job is to provide a complete record and the current standard, not to write the clinician's score.
Conclusion. Keep the record complete. Here is the full filing checklist. Work it in order and keep a copy after the last step.
8 steps. None says estimate the payment from TikTok.
The busted board remains tragically unemployed.
Watch the official public domain Air Force excerpt. It moves through SGLV 8600, names Part A and Part B, and routes the completed form plus supporting medical records to the appropriate service branch.
That is better than a screenshot. The workflow is visible.
Before any appeal template, ask one question. What exactly did the branch say is missing? The denial reason controls the response.
Yeah, if the branch denies the claim, begin with the denial letter, not a generic appeal template. VA says the letter will tell the claimant whether to use SGLV 8600A and how long the appeal window lasts. Preserve the notice, identify the denial reason, compare it to the exact evidence submitted, and answer that reason directly. A new stack of unrelated records can obscure the defect instead of curing it.
So the stated denial reason controls. There is no universal appeal countdown we should invent here.
The denial letter controls the form and the clock. Read it before drafting the response.
The premise changed. This is not a secret $100,000 injury check. It is a $1 insurance rider with a published loss schedule, a direct cause requirement, and a clock. That is narrower than the viral claim and far more useful than a myth.
Walk away with this. Schedule first, record second, form third.
Use the free VA resources at va-professorerica.com as a starting checklist, then verify the current TSGLI page, loss schedule, and form before you file. The published source should win every disagreement.
Tiffany, what should someone do tonight if they think an old injury may fit?
Here's what I'd actually do tonight. Don't predict the check. Confirm the SGLI policy on injury day, open the current loss standards, write the injury and loss dates, and mark the records that prove causation. Then decide whether the current form fits.
If the record is complex or the denial reason is unclear, a qualified service officer or branch casualty assistance contact can help organize the issue. Advice should sharpen the evidence question, not replace the official standard.
If this made the $1 rider finally make sense, like the video and subscribe for the next benefit the group chat skipped. Which missing link would you check first? Coverage, the scheduled loss, or the medical chain? Take care of yourself, keep the source open, and I will see you next time.